My name is Jason Thomas. On behalf of Deborah Buford, Manager, Employee Accountability and Workforce Relations at the U.S. Office of Personnel Management, it gives me great pleasure to welcome you to today's live stream training entitled Addressing Sexual Misconduct and Harassment, Maximizing Accountability. Our office presents live stream trainings in support of our ongoing effort to bring relevant and reliable developmental opportunities to federal sector employee and labor relations practitioners. Today's presentation will provide an overview of accountability for sexual misconduct and harassment in the workplace. Topics covered in this presentation will include sexual harassment as a matter of law, approaches for addressing sexual misconduct in the workplace, and recent EEOC and MSPB studies on harassment. Moreover, the presenter will discuss agency responsibilities and recent case decisions. We encourage everyone to make the most of this live stream training, including asking questions of our presenter. You may do so by sending an email to employeeaccountability@opm.gov. We will do our best to field as many questions as possible. Please note that shortly following the presentation, everyone who registered will receive a hyperlink to an online evaluation form courtesy of surveymonkey.com. Simply click the link, follow the instructions, and your valuable instant feedback will be sent back to us. Your feedback is important to us and helps us plan future trainings. We are pleased to have as today's presenter Mark Maxon. Mark currently serves as a member of the Senior Executive Service as the Assistant General Counsel for Administration at the Nuclear Regulatory Commission. In his current position, he regularly provides legal advice on harassment and other civil rights issues. He has written 2 anti-harassment policies for the Department of Labor and the Nuclear Regulatory Commission. Mr. Maxon has over 35 years of federal sector employment law experience, including extensive experience in investigating, advising, training, and litigating sexual harassment and other forms of harassment under various civil rights statutes. Please join me in welcoming Mr. Maxon.
Hello. I'd like to first express my appreciation to OPM for having the opportunity to speak to you about this incredibly important subject area. You can't look at the newspapers without seeing reference to the Me Too movement, without seeing allegations of harassing conduct in businesses, in churches, in the government, in Congress. And it's appropriate for us to have a conversation about what we in the federal government can do to prevent or minimize harassing conduct from occurring in the workplace. Next slide, please. What we are going to be talking about in this presentation, as indicated, is recent EEOC and MSPB studies on harassment, one in 2016 and one in 2017, and the role of the ER specialist, that's the employee relations specialist, in addressing allegations of sexual misconduct and harassment. The legal definitions of harassment, how to draft a charge of an employee who engages in harassing conduct. We're also going to talk about sexual misconduct and other forms of harassing conduct cases that have been addressed by the MSPB and the EEOC. We're going to talk about best practices in creating a model anti-harassment policy and procedures for reporting harassment, and we're going to talk about other tips with regard to avoiding and best practices of eliminating harassment in the workplace. Next slide, please. So I think what I would just like to do is begin by first reflecting on, which is attached to materials that were sent to you, a 2016 EEOC Select Task Force and studying harassment. And what that task force found was many important things. Number one, workplace harassment persists and continues to be a problem in most all workplaces. That I think the percentage for employees in the general workplace is about 25% of employees, particularly women, reporting harassment, and that when harassment is actually explained and defined as many kind of different behaviors, from sexual coercion to invading space to inappropriate comments and jokes. Some studies that the EEOC referred to found that women, for example, experience sexual harassment as experiencing it in their careers 60% of the time. The next part is the interesting finding that workplace harassment too often goes unreported. Employees, according to the EEOC study, who experience harassment often endure it and often avoid. They may leave the agency, they may essentially, or the employer, or they may just, in essence, suffer in silence. There is a, and one of the things I think the EEOC policy and task force talks about is that oftentimes people are afraid to report the harassment. Oftentimes they are fearful of retaliation if they report it. Sometimes the reasons they don't report it is they want to fit in. So they experience harassing conduct but tolerate it because they want to fit into the culture accordingly. Whatever the case, it would be important for, particularly in a federal government agency, to ensure persons and employees that they do not have to endure harassing conduct in the workplace. And one of the things we're going to talk about, of course, is taking the appropriate steps to minimize that. There's also a compelling business case for stopping and preventing harassment. There's tremendous data in both the EEOC report and the MSP report that literally millions upon millions of dollars are spent in lack of productivity of employees leaving an organization because they experience harassment. And here is, and the other part of it is to remember that it is not just the employee that is actually being harassed that is adversely affected by harassment. The EEOC does an extraordinary job, I think, underscoring and emphasizing about the impact of harassment on the bystander, the person who observes the misconduct, who observes the sexual comments and the sexual touching and related things by either the supervisors or by the coworkers accordingly. So, and of course, anybody who has ever engaged in a harassment investigation, I have unfortunately had that experience many a time, and in my 35 years, the impact of an individual who has experienced sexual harassment, depending, of course, on the facts of the case, can be devastating, and the impact of learning about the harassment, reporting it, talking to your peers, and experiencing the problems associated with that is kind of documented well in the EEOC report. The key component is there's an important business case for stopping and preventing harassment. The next point the EEOC report makes is it starts at the top. So first, we all understand that in order to have an effective anti-harassment policy, you need to have leaders who are going to communicate that. They're going to have to say, we will not tolerate harassing conduct, and make it clear. But there's so much more, because stopping harassment means, or minimizing it, means more than just words. It means action. It means, according to the EEOC, that in addition to just words, you have to also have effective systems for reporting harassment. You have to have accountability. When the harassment occurs, what are you going to do? You've got to know what your harassment policy is in addition to it being effective. For those of you who are out there, if any of you are questioning the effectiveness of the leadership and accountability on dealing with harassment, there's one very effective way of Elise testing. Think to yourself, do you know what your harassment policy is? Do you know what it says? Do you know its definition? If someone were to harass you or to a friend of yours, do you know where to go? Do you know how to report it? If you don't, if you're not aware of it, then I would suggest to all of you that that is a really, at least a good first test, that more has to be done to publicize that policy, to make it better. And of course, we're going to talk about how to establish a model anti-harassment policy. And then the anti-harassment policy will not stop on its own. That the EEOC acknowledges the employees need to report it. And here's some interesting information from the EEOC, that it should not be just the victim, that ample studies were conducted about the power of the bystander. So no one short of, oddly enough, Lily Tomlin said this: I kept wondering, in the context of harassment, why somebody wasn't doing something about this until I realized I was somebody. The EEOC explains that if you, as a bystander, observe the harassment, you should stop it. And training, as we will talk about what effective harassment training constitutes, should extend to the bystander. There should be a message, as we will talk about at length, that makes it clear that if you work for the federal government, you have a right to come into the workplace and work in an environment free from harassing conduct, and that the agency wants you to report it if you experience it, and if you do, that it will take appropriate action. You in the audience are mostly employee relations specialists, but some of you are, of course, attorneys, some of you are EEO specialists. Whatever the case might be, we are going to talk about what we, as attorneys, employee relations specialists, and EEO specialists can do as a team to minimize harassing conduct in the workplace. Next slide, please. So the other part I just wanted to point out is that in 2018, the Merit Systems Protection Board just issued, of course, earlier this year, a new study on harassment in the workplace. So it appears from all the data that there is less prevalence of harassment, say, in the federal government than elsewhere if you compare the two studies, but I'm not here to characterize and evaluate the quality of the studies, but just to find them. But here's what it does conclude. The MSPB finds that 1 in 7 federal employees have experienced harassing conduct in the last 2 years. This is sexual harassment. And they have indicated that 1 out of 5 women have said that they have experienced sexual harassment, and that harassment, by the way, is defined by specific behaviors. Like it includes sexual coercion, sexual, leering, views, touching, etc. They make a list of 7 or 8 kinds of behavior that could make up sexual harassment or behaviors that are tantamount to sexual harassment. In any case, 1 out of 5 women are experiencing, 1 out of, I think, 8.7 men are experiencing it. I just want to say that, in my judgment, having 20% of women experiencing harassing conduct in the last 2 years is totally and completely unacceptable. And we, as the employment law community, must take meaningful steps to try to prevent that. Next slide, please. So what I want to talk about now is the critical role of the employee relations specialist in promptly and effectively addressing harassment in the workplace. So essentially, what the employee relations specialist can do is many things. And for those of you who don't know these terms, of course, an employee relations specialist is normally dealing with performance and with conduct actions. And you play the most critical role, because if an employee engages in harassing conduct, the most effective way to minimize that from having it occur in the future is to ensure that the agency is accountable. Accountability could be counseling, it could be a verbal warning, it could be a 5-day suspension, a 10-day suspension, it could be a removal. But if there is misconduct in the workplace, the employee relations specialist, in the form of addressing sexual harassment in the workplace, can play a critical role in ensuring that the agency is accountable. In addition, according to, and we'll talk more about this in the future, according to a 2004 EEOC study, it is effective to have an anti-harassment investigative policy and practice and procedure outside of the EEO complaint process to address harassment effectively and promptly. This means that in many, many agencies, and including the EEOC, that the best practice is to have an employee relations specialist actually conduct the harassment investigation. What I find when I talk to managers, which I do quite often, not only in my own agency but in various other agencies, is, and with HR folk, is that people view harassment as an EEO issue. But the key component is harassing behavior, as we will define shortly, is misconduct. And misconduct needs to be addressed at some point by an employee relations specialist, and to have fair, consistent, effective remedies for harassing conduct in accordance with the Douglas factors, the 12 factors for mitigating, is a critical component that the employee relations specialist can effectuate. Next slide, please. And I should also say on the last point is that the employee relations specialist can also play a critical role in conducting training and other related things. So dealing with harassment. So again, the critical role, I'm sorry, could you go back one slide? The critical role of the EEO specialist and how it differs from the employee relations specialist. So remember, although of course the EEO specialist plays an important role conducting training and highlighting that the agency will not tolerate harassing conduct, the key component is most EEO specialists are basically responsible for filing and processing effectively complaints under 29 CFR 1614. And the role in that process is to determine whether or not there is a violation of law, a violation of, say, Title VII, or if it's an age harassment under the ADEA, or disability, the ADA, or those kinds of things. The key component, as we will see, is if there is harassment under an agency harassment policy that could have a lower threshold than a Title VII requirement, hopefully we can set up a process where we can stop harassment at its earliest stage before it emerges into a violation of law. I also want to point out, because that I strongly believe it's almost like an inherent value that an attorney can play a critical role in affecting the culture of an organization and making sure through the legal advice that it effectively provides to the HR office and to the EEO office to ensure that there is not a tolerance for harassment. When I say not a tolerance, I don't mean that any employee that engages in harassment should be fired, but a fair and appropriate consideration of penalty should be appropriate. And one last thing. I want to just emphasize, in dealing with harassment, it should be addressed as a team. You have the EEO specialist who's dealing with the 1614 EEO complaints. You've got the agency employee relations specialist instituting its policy. You've got the employment lawyer. Together, if you work together in concert through training and communication, understanding the hot spots in your organization and what needs to be done, you can make this a better place. You can make your organization a workplace that minimizes harassing conduct. Next slide, please. So let's get starting into the substance of this. So who can commit workplace harassment? Anyone is the simple answer. It could be a management official, it could be a coworker, it could be a non-employee, somebody in the public, a contractor could be coming in and harassing an employee, or an employee could be harassing a contractor or somebody in the public. The point here is not to just limit it to just employees. Next slide, please. Where can harassment take place? So this is really very interesting. And my view is very often we in the employee relations community focus on harassment, of course, in the workplace. But we also remember that any kind of disciplinary action that occurs must have a quote-unquote nexus with the efficiency of the service. Clearly, sexual harassment that occurs in the workplace is going to have almost a presumptive nexus, and the MSPB cases state that, and of course EEOC also provides evidence of that. But harassment can occur off-duty. You go across the street after work hours for a few drinks, and the next thing you know, a coworker is being harassed by another. When I say harassed, I'm talking about maybe an unwelcome pass or an unwelcome touching or unwelcome, inappropriate sexual comments. And so if it happens in an isolated way, as we'll see, it may not violate Title VII, but if it affects that employee coming into the workplace, perhaps they now start avoiding employees and others, the employee who allegedly harassed them, it could be a basis to find a nexus. And one of the interesting areas when we get to nexus, it's quite a complicated world, my friends, includes social media. So one of the things, one of the cases is a case called Knowlton versus Department of Transportation. Now that case is not an MSPB case, it's an EEOC case, but it's interesting because comments were made on a Facebook account in which about going to a fast food place and getting some food there. In that case, it wasn't a sexual comment, but it was a racist comment that was made referring to a coworker. And that information got back. So on the Facebook account, there was a racist comment made, and that was the basis of an EEO complaint. I'm hesitant to repeat it. Read the case if you would like, but it was a pretty horrific thing. part of the problem is people take risks. They communicate through their Facebook accounts about their colleagues. If it gets back to those colleagues and it's affecting their colleagues, they learn about it and it adversely affects their ability to work with others. These kinds of harassing behaviors can be problematic. We're going to talk in a minute about what violates Title VII and what could otherwise just violate your agency harassment policy that could warrant disciplinary action. But you should be aware that harassment can technically, as long as it meaningfully affects the workplace, can occur off-duty. The other case on this slide is a case called Shannon versus Department of Veterans Affairs, and I just wanted to mention that in brief because that was the VA had a policy where it didn't allow a, let's say, nurse to have a relationship with the patients. And essentially through Facebook, this one nurse was violating that policy by communicating with the patient. And even though it was off-duty and on her own time, the MSPB found there was a nexus in violating that policy. That's not exactly a harassment case, but it underscores the fact that social media off-duty conduct can affect the workplace. Next slide, please. So now let's get down to the law. And what are the elements of a legal claim of sexual harassment? So first of all, there is the case of Meritor Savings Bank, which emphasizes that harassment based upon an individual's sex or gender is actionable and is a violation of Title VII. And here is the elements of a claim of harassment. It must belong. The person must belong to a statutorily protected class. There must be a basis for the claim of that class, meaning the statement is based upon a person's race, or in this case, since it's sexual harassment, their gender, that the employee was subject to unwelcome conduct related to their membership of the class, that the harassment complained of was based on his or her protected class, again, and that the harassment had the purpose and effect of unreasonably interfering with the work environment in which it's a hostile work environment or would otherwise be a quid pro quo, meaning that's another theory of liability in which instead of creating a hostile work environment, for example, a manager, somebody with authority basically is making actual personnel decisions, let's say to fire somebody who won't agree to sleep with them or otherwise, or won't promote them accordingly. The harasser's conduct should be evaluated. First, they must have a subjective view that they've been harassed, and but in addition to that, it must ultimately meet an objective viewpoint of a reasonable person. So, if a reasonable person, this is again under the law of Title VII, would feel under the total circumstances that there was harassment, then the complainant will prevail. If an objective, reasonable person would not, of course, they would not. So, next slide, please. So, ultimately, slide 10 is focused on elements of a legal claim of sexual harassment or other prohibited harassment. You need to ask yourself the question: was the harassing conduct based upon the employee's complainant's legally protected status? Was it because of that protected characteristic? Was the conduct unwelcome? And of course, meaning that it was unsolicited and the person did not desire the conduct, the adverse conduct. Was would a reasonable, objective person find the conduct offensive? And under the reasonable, objective person, the next question would be, did the harassment again involve a tangible employment action such as the firing, demoting, or failing to promote an employee because she rejected advances, or otherwise create a hostile work environment? And that means that there's a way of showing liability in a hostile work environment, even if your work environment, even if no personnel action was taken against you, as long as you can show that the person created an intimidating, hostile, or offensive work environment that adversely impacted conditions of employment. Again, we're right now just focused on the law. We'll talk about some cases to flesh some of these concepts out. In order to determine whether there's a hostile work environment, it requires proof that the misconduct involved was either severe or pervasive. Severe is really basically the seriousness of the event. So clearly an inappropriate touching, depending of course on the touching, can in and of itself be severe. So if when we get to talking about actual MSPB cases, you'll start to notice that physical touching, there's a number of cases, unfortunately, we're going to talk about where people are receiving a forced kiss. Those kinds of things are enough to create a severe violation, and a single incident would create a hostile work environment. The other aspect is whether it's pervasive. So there is, for example, when we go through this, one of the age cases that was in your handout that I kind of gave you like a 10-page document that summarizes a series of EEOC decisions where they found harassment had occurred based on age. You know, there were comments in there that an individual was an old guy. There were allegations and that they're saying, you know, can you remember which way you're going? And they would make, inappropriate kind of comments that were age-related. The thing about it is, a few isolated comments and does not necessarily violate the Age Discrimination and Employment Act, but this individual had to endure that kind of behavior on an ongoing, daily basis. So it's that kind of thing. When somebody in the context of sexual harassment is essentially enduring, so for example, an inappropriate glare or or a leer is in and of itself probably not going to obviously violate Title VII. But there are cases actually out there where somebody would be staring at somebody's a female body part so profusely that they were nicknamed King Lear. And in that kind of a circumstance, when it becomes so pervasive in the pattern, even though a single isolation of it would not violate Title VII, over a period of time, it would violate. And then comes the fact, is the agency liable? And liability can be is a very complicated area in harassment law. And I think you all need to understand it because it will affect, hopefully, the way you make charges as we talk through this. So again, the protected basis and causation, it has to be based on race, color, gender, national origin, religion, age. We're talking, of course, in this case, mostly about sexual harassment, so it has to be mostly sexual harassment based on gender. And causation, you have to show, again, because of a protected characteristic. It could be facially discriminatory conduct, racial epitaphs or graffiti. It could be, again, inappropriate touching. It could be context, inflection, tone, etc. that could create satisfy that causal connection. Unwelcome conduct occurs when the employee did not solicit or invite the conduct and regarded it as undesirable. We'll talk about some cases in this where the agency could try to take a disciplinary action, but the employee actually said, I didn't have a problem with it. There's a case which we'll talk about. Somebody was actually kissed on the cheek, and and they were charged in their action, but the individual who were kissed on their cheek as one of the specifications in the disciplinary action basically said that she did not perceive that to be a harassing conduct. If it's not subjectively unwelcome, it can't possibly constitute harassment. But in addition, as we said, it also has to be objectively a reasonable person, an objective requirement. So hostile environment, examples include ridicule, and I'm sorry, if you could go to the next slide, please. I'm sorry, next slide after that, I apologize. Ridicule or mocking, offensive and derogatory words, phrases, epitaphs, jokes, suggestive comments and gestures, unwelcome requests for sexual favors, exposure to offensive photographs, explicit emails, drawings, cartoons, or internet transmissions, touching, kissing, pinching, grabbing, gesturing, or stalking are all a wide variety of things. And I do just want to say to the employee relations specialists and my EEO specialists and attorneys out there, I just want to just take a moment and remember that in these cases that occur, that there is such a thing as a discovery. And when we think about email, so if an EEO complaint is filed and eventually it gets before the EEOC or before the Merit Systems Protection Board, if an action takes place, discovery is part and parcel of the process. I just wanted to remind you all that when you're dealing with the E in email, that over the years, the word electronic has been replaced, in my own judgment, by the word evidence. Remember, when you get that email, if it shows up, can adversely affect an action, so you can rely on decisions based upon the email traffic, and be wary when you're preparing for your case, whatever the case, either before the EEOC or the MSPB, that it addresses as you know, what the evidence shows. A major area on the next slide, please, is whether the conduct is severe or pervasive. So I'm starting now to move a little bit into some essentially case law, but understand that in order for it to be a violation of Title VII, the workplace has to be permeated with unwelcome, discriminatory, and ridicule or intimidation that is sufficiently severe and or pervasive to alter the conditions of employment. Again, severity, it touches serious nature of the violation, like a touching. I did want to point out, as we get to a couple of cases later on, that words can meet the severity. There is, for example, there is one case in which somebody is referred to as a quote-unquote Hebrew slave. That statement alone was enough to satisfy the severity requirement, and we'll talk about that case later. There's another use of the N-word in and of itself could amount to a violation of Title VII on the basis of severity, even if it's isolated on one instance. Pervasive addresses the frequency of the violation, again, like the number of times. So if you look at a case called Booker versus Veterans Administration, an MSPB case, the MSPB acknowledged that an isolated incident of sexual harassment must be, quote unquote, extremely serious to violate Title VII. And in Booker, a female employee was pinned upside a locker and forcibly kissed without her consent. She had her arms pinned behind her, and that single incident was enough to violate Title VII and result in serious disciplinary action. Again, I've cited some EEOC case law in this document to reemphasize that a single incident will generally not be regarded unless it is in the order of something, very serious, like I've just kind of discussed. It could be the N-word. It could be a single incident in a word, but it's very rare for that to happen. Next slide, please. Okay, one last part, and then a couple of slides dealing with the law, and then we're going to start talking more about what to do if you see harassing conduct in the workplace. Agency liability for harassment. So here's the thing. The agency will be automatically liable if a manager engages in tangible employment harassment. So, for example, if the manager inappropriately offers, says to someone, either you take this job or if you want this job, you're going to have to sleep with me. If those are the facts, the agency is automatically liable for that, and there's no, essentially, defense for it. But if the allegation is a tangible employment, is a hostile work environment harassment, you may have a defense. So, for example, if the agency can show that it exercised reasonable care to prevent and promptly correct harassment, and that the employee failed to take advantage of the corrective action. Well, we're going to talk about on the next slide, we're not going to go there yet, but when we get to that next slide, you will then understand that an agency can effectively avoid harassment if it has a meaningful anti-harassment policy of a certain character, which we will explain, and the employee in a hostile environment fails to report it. If the employee is trained about the policy, if the employee knows about the policy, and if the employee then doesn't use it and report it, the agency will not be liable. This is if the manager engages in the harassment. So if they didn't report it promptly, they didn't take, in other words, reasonable care. That's another theory. And it's one of the best reasons to create an effective anti-harassment policy. When you're talking about agency liability for a coworker who engages in harassment as opposed to a manager who engages in hostile work environment harassment, the focus of the EEO judge or the Merit Systems Protection Board judge who's going to look at this is, did the agency take prompt and appropriate action to correct the harassing conduct? So once it is reported, the agency is then on the clock. If it sits on its hands, it's going to be liable. If it acts promptly to separate the parties, if it acts promptly to look into it, if it acts promptly to take disciplinary action, then in essence, it could avoid liability in a coworker case. Now, one of the things I just wanted to emphasize too is that in the MSPB study, they clarified that 45% of allegations were coworker harassment, that actually only about 23% of sexual harassment cases were manager focused harassment. So it's incredibly important for you to train all employees, as we'll talk about harassment, and to act promptly and effectively. The agency may be able to avoid harassment when that occurs. So the bottom line is, if an employee relations specialist acts promptly and effectively when addressing an allegation of harassment, they can actually help avoid liability. So it's very important that we act accordingly. Next slide, please. The affirmative defense of reasonable care. So if you recall, I talked in the last slide about the issue of a manager who engages in hostile work environment harassment against an employee, let's say that they supervise. So you can avoid, the agency can avoid liability if it has established an effective anti-harassment policy. That is a clear explanation of prohibited conduct, an assurance that the employee who makes the complaint of harassment provides information related to such complaints will be protected against retaliation. It needs to say that. A clearly described complaint process that provides different avenues of a complaint. Let me emphasize what that means. Is if you have a harassment policy and all it says you feel you're discriminated against, file an EEO complaint, that's not going to do it, meaning under 29 CFR 1614. This, in order to have an effective anti-harassment policy, there has to be this policy outside the EEOC complaint process. Number two, if you have a complaint process that says that you must provide allegations of harassment just up the supervisory chain, that's not going to work. Why? Because the EEOC recognizes, as did the Supreme Court in cases Farragher and Ellerth and others, that essentially the failure that essentially sometimes employees are not going to have a confidence in a reporting structure if it's just up the chain of command. Why is it? Because you got the good old boy network. You got the supervisor who's friendly with the alleged supervisory harasser, and you're like, I'm not going there. That's why it's important to have another place to file. In order to have that affirmative defense of reasonable care, you must have an effective policy. So those of you who are unfamiliar with your policy, you have to know what that policy is. But those of you who do have the policy, you need to go back and look. Does it have an effective process outside the chain of command? Usually by creating a reasonable, a disability, I'm sorry, I'm back to my old disability law presentation, by having an anti-harassment designated official, oftentimes in the HR office or in some other component, essentially, of the organization. Then the complaint process must provide a thorough, prompt, and impartial investigation, and that the employer will take immediate and appropriate corrective action, which means disciplinary action, which determines that harassment has occurred. You need to disseminate that policy. You need to share that policy. People have to know about it. Ladies and gentlemen, you can have the most effective policy in the world, but if people do not know about it, it is useless. So you have to get out there. You got to train them. You got to share it. You have to talk about it. It's the only way that not only can you affect the quality and eliminate harassing conduct in the workplace, but as well from a liability aspect, it could be an important determining factor. So what I wanted to go to the next slide, please, and later on we'll talk about the specifics of exactly how to create an effective anti-harassment policy. Right now, I don't know. Do we have any questions at all?
We do have a couple questions
Okay.
from our webcast viewers. Regarding pervasive misconduct, in order to find pervasive misconduct, must it be against a single individual or can it be behavior toward any number of people? And if it is against groups, must it be regarding a single protected class?
So essentially, if there is an allegation of racial harassment, it doesn't have to be just one person that's making the inappropriate racial comments or the sexual comments. It could be a number of employees that are making those comments that is making the individual feel essentially uncomfortable. And but ultimately, the totality of the comments have to be either severe or pervasive. Severe if there's somebody using, an N-word, that may do it, or it must be from a quantitative process, a number of allegations raised by a number of individuals can create it. Remember, one of the things that the EEOC harassment policy report found, that one of the areas where environments were most prone to have allegations of harassment was when it was dominated by one race or one gender, because the dominating gender, say you're in a group of white males, and you're sitting and you're joking around and you're the only woman in the organization and you're listening to all these sexual jokes back and forth. After some point in time, it becomes part of your life. You walk in and you're hearing an inappropriate sexual comment. You don't have to endure that. You can raise a complaint, and at some point, it will. It sounds, if it happens frequently enough, it will violate Title VII. Any other questions, sir?
Yes, we have one more question. Do you know what a good best practice recommendation would be when refer sexual misconduct to local law enforcement authorities? And does that standard apply even if the person that was assaulted is reluctant? And lastly, do you contact the local authorities at the point the complaint is received or when an investigation is completed?
I would say when the report is received, the first thing I would do with something like that is I'd speak to my Inspector General's office, and I would let them know that an allegation of assault had been raised. I would also talk to my Facilities and Security office, and that would be the first thing. And they would be responsible for reaching out to the police. You, as the employer relations specialist, should not be reporting to police, but you should know in advance and be thinking about what would happen if that does happen. Now, one aspect, which we'll talk about again later, but it's important to talk about now, is the concept of interim relief. So when somebody raises an allegation, you have to contemplate, do I want to exercise interim relief? And usually a designated official will explore that issue, meaning, do I want to separate the parties appropriately? In the context of a sexual assault case, what I would tell you is immediately those two folk have to be separated. Because if somebody is assaulted sexually and the agency is allowing the two just to be working down the hall like that, the liability will skyrocket, particularly if it happens again. So that's the first part. So from an interim relief, a best practice would be to separate the parties, contact the IG or your defense or your security facilities people to reach out to the local police to immediately report these allegations as appropriate. But again, they are trained to determine whether it's appropriate to report that, and it's a case-by-case assessment. Okay, moving on, and I am now on slide 16. So I started off talking today about the role of the employee relations specialist, and this entire presentation is about agency accountability. I just want to emphasize, if there is harassment in your organization, and the key component, other than, in addition to having an effective policy and letting people know about it, is that there are consequences for the harassment. All we have to do is look at the news and listen to all these allegations that apparently had been going on for days, weeks, years, where because somebody was a high-level employee or whatever it is, they were just tolerated. You can't tolerate misconduct. Misconduct, we all know, breeds misconduct. So the key thing is, in addition to an EEO complaint process being filed, the idea is if an allegation is filed, and let's say it's filed under the agency's anti-harassment policy, we'll talk a little more about that, then essentially it's investigated at a point certain. When you have determined that harassment has in fact occurred, your responsibility at that point is to consider appropriate disciplinary action. Usually, the disciplinary action occurs with the immediate supervisor of the employee who engaged in the harassment. What I wanted to talk about in slide 16 is the following, is that it is probably a best practice when you are charging an employee who engages in sexual misconduct, not to charge them with violating Title VII and sexual harassment. And why is that? We know that depending on what you charge, you have to prove it. You are, in essence, your lawyers become the prosecutors of the charges that you write. If you charge somebody with sexual harassment in violation of the law, they are going to have to prove that the conduct engaged in was severe or pervasive, was unwelcome, was based upon gender or race or whatever it is, and would have to prove the liability issues as appropriate. On the other hand, if you charge somebody with a simpler version of that charge, such as conduct unbecoming a federal employee, such as making a conduct of an inappropriate sexual touching, if you charge various types of charges like that don't, and another charge which we'll talk about depending on the situation is violating your agency's harassment policy, which is not necessarily based on Title VII, you will make it easier to prove the charge. So I wanted to emphasize that because, remember, in order to make your organization accountable, you have to win your case. And to win your case, you want to do it in the most effective, easiest way to prove it. So it's not always easy to prove severe or pervasive, but it is easy to prove that on such and such a date, you made a sexual comment to somebody that was inappropriate. If you charge somebody with that, you don't have to prove it was severe or pervasive. You can just prove it was an inappropriate sexual comment or series of comments. It may only be worth a one-day suspension or a three-day suspension, or it could be a series of them that gets you to above the MSPB threshold of 15 days or so. But up to removal, whatever the case is, you need to think about the best way to charge the case. So what I wanted to do, next slide, is talk about a series of cases. So in this particular case, you had a employee that, in this case, is Al-Sadek versus Department of Army. And in that case, a supervisor was resting his hand on an employee's thigh. And then the person was pushing themselves between themselves and the copy machine, and then rubbing this person's leg in a sexual manner. And what the Alsdeck MSPB case said is that the MSPB, the agency policy, was not based upon Title VII, but its own agency anti-harassment policy. So it didn't really cite too much to Title VII. It just described the behavior that would not be tolerated, and much of the behavior was like Title VII, but it didn't actually track it. It didn't, emphasize words like severe or pervasive or something like that. And in those circumstances, the agency found that a demotion of the supervisor with a 30-day suspension and a 2-year prohibition violated the 2-year prevention from that individual functioning as a supervisor was upheld by the board. But in the course of doing it, they emphasized that the agency's, it was based upon the agency's policy, not Title VII, and therefore they were effectively able to prove just the violation of the policy, not necessarily the law, and it was essentially upheld. What I wanted to next talk about was a case called Salazar versus Department of Energy. Now, in this case, the agency had a harassment policy that talked about Title VII of the Civil Rights Act. And in that policy, it laid out in great detail with citing to EEOC regulations and almost taking the words verbatim from that regulation. So what the MSPB in essence found was that the anti-harassment policy tracked Title VII. And in doing so, by charging a violation of of the anti-harassment policy, the MSPB found that you had to prove that the individual engaged in a violation of Title VII. So the policy was an issue. Now, in that case, here you had a supervisor based upon a single call to a female employee. And it wasn't an employee. It was, I think, a contract specialist, and not a supervisor, I apologize. It was a contract specialist of some sort who calls a contractor and makes a call after seeing her picture somewhere, and calls her up and says, "You are beautiful, and says that over and over and over again, making her feel very uncomfortable, and asked if she was married and told that she was a lucky man. And she's upset by that, and she reports it, and the agency suspended this guy for 30 days. The agency lost. They lost. Why? Because even though that conduct was inappropriate, it didn't amount to Title VII violation. It wasn't severe because there was no touching. It was just words. It only happened the one time. Pervasive. Now, here's the point: if you had an agency anti-harassment policy that if you have an agency anti-harassment policy that doesn't track Title VII and just said inappropriate communications of a sexual nature or otherwise are inappropriate and making people feel uncomfortable based upon their gender, which this would probably qualify for, that person could have gotten some sort of suspension. I don't know, 30 days, but you could have justified that. But the bottom line here is because the agency policy was written like a policy under Title VII, it didn't qualify. So that's a good example of how you charge a case could make a difference. And again, Gregory, which is on the next slide, essentially is talking about various examples. It's one of the more recent cases. Again, a female subordinate who was stated that you have a working tongue and stuck it out in front of her in the presence of a witness and made some other inappropriate comments, etc. Again, the agency was required to apply Title VII standards because the way they wrote the charge, and they lost. The agency could have charged with inappropriate conduct, the Gregory court said. If it did not want to meet the title standard, it was not required to cite to an agency policy that tracked Title VII to such a charge. So I refer to Gregory, and I suggest to you again, rely on inappropriate conduct kind of charges and these kinds of things. Let the specifications, the facts speak for themselves so you don't get caught up in a Title VII analysis. In another case called Viennes, next slide, please. It's another MS, another case. An AJ mitigated a case to 90 days, was overturned. In this case, again, the individual was pushed up and overheard, I guess, was kissed, excuse me, and did not subjectively affect her working environment. And again, this was an example of, even though she was sickened to her stomach and she had to leave the premises, at this point, the 90-day, the removal was upheld. So just to clarify, there were like 4 instances. One was a forced kissing. The forced kissing in and of itself was a justification to remove this employee just based on one circumstances. It was interesting, though, because they had charged in a manner consistent with Title VII that comments like, "You look sexy today," and everything like that were not sustained. So the removal was ultimately sustained, but it was based just on that one incident of essentially kissing in which it occurred. And so I just wanted to emphasize, too, that in putting on a case like this, ultimately what the court looked like, or the board in this case, was the fact that this woman was, again, sickened to her stomach when this forced kiss was placed upon her, and the evidence that she had to leave the work premises and she felt ill and couldn't come back to work was underscoring the severity of the misconduct and warranted the harassment finding and upheld the charge. Another case, next slide, is Booker versus Veterans Administration. Booker is an interesting case. It's a coworker case. 2 staff pharmacists were friends, and the record showed a male and a female. I don't know what happened exactly in the case, but something caught his eye. He kissed her, closing the door behind her, and the door locked. And then he began to kiss her again. She turned her head to say no. He held her arms while he kissed her, and again, she felt kind of pinned up against the wall. Then she was incredibly upset. She felt betrayed. This is from the record. Betrayed, shocked, trapped, scared. the employee comes in the next day. He apologizes. He says, "I'm sorry, I don't know what came over me." He says, and initially the argument was he had a 17-year record, no prior offense. An otherwise good employee, a good record. He lost his job because the agency considered the impact. You're going to send this guy back, into that work environment and take a risk with other individuals, and the severity of the offense was so significant. She was not able to work again. She had to, she had to leave the workplace again. It justified the individual's removal. Next slide, please. I want to talk to you about the credibility of witnesses and the Hillen factors. So Hillen is a case that you should all know, so afterwards you may go back and read it. And in it, it determines how do you determine credibility. Everybody here knows that in the world of harassment situation, oftentimes it's a he said, she said situation. How do you determine who is more credible? So eventually, if you are a lawyer litigating a case before the MSPB, you're going to apply the Hillen factors. There is guidance also on by the EEOC that I attached on determining liability of supervisors. That includes EEOC's aspect of how you determine credibility, and they're very similar to the Hillen factors. So, or you might be an EEO specialist that is trying to determine in a final agency decision whether or not there's actually been discrimination. Or you might be an employee relations specialist trying to figure out, how do I prove what I'm going to say? And you might even be writing up the report. I have in the past relied on Hillen to clear the air for me. So here are the factors just to consider the difference in credibility: the opportunity and capacity to observe the event or the act. So, to the extent that the allegations or the testimony that you're addressing is based upon personal knowledge and, that's actually observed, and that it makes sense that you actually had the opportunity to observe it, is a factor to consider in assessing the credibility of a witness. Character. You want to look at prior misconduct. Does this person have a reputation for engaging in this kind of conduct? Does this person have a previous record of falsification? According to the MSPB, gave an example of something that would undermine that person's character and thereby undermine their credibility as a witness. Prior inconsistent statement, failure to deny the charges when responding to a proposal is an area. So let me clarify that. So essentially, if you are saying that one thing happened one way, and later on, of course, you're saying it happened another way, under what Hillen says is you can consider that as a factor in assessing essentially whether or not there has been whether the witness is credible. But here's what I thought. When you read Hillen carefully under prior inconsistent statement, they clarify that if the person goes to an oral reply and does not deny the charges when responding to the proposal, and then subsequently on the witness stand says, I denied the charges for the first time, that is a prior inconsistent statement according to the MSPB in Hillen and can be relied. So I thought that'd be interesting. Another factor in determining credibility is bias. Are you close friends with the witness? Is there some kind of connection? Is it your spouse that's testifying on your behalf or whatever it is? Obviously, bias can affect credibility. Contradiction by or consistency with other evidence will determine credibility. Inherent probability. So if it's improbable what you're saying, then that's going to affect it. So in a case, for example, where a special agent who trained in criminal investigations said, I didn't realize that the stuff I was taking was government property. The MSPB found that was not probable that that would have occurred. And so that is an evidence of a lack of credibility, and of course the demeanor of the witness. And when you're conducting an investigation, next slide, that's an important factor. I also want to take a moment to talk about a relatively new case, an MSPB case, that deals with none of the allegations, none of the nuances that I've already talked about. But it is something that I think we should talk about. It's a case called Sabio, and this is for my attorney friends that are out there. We know that as a general rule, we know for a fact that before the MSPB, you cannot file a motion for summary judgment, say in the context of anything, let alone an allegation of harassment. So for those of you who don't know, a motion for summary judgment applies when there is a violation of when there are no facts in dispute. And you could say, why do we have a hearing? Let's just file a brief that dismisses the case if it's not in dispute. Well, the MSPB won't accept that. But in a very recent case, Sabio versus Department of Veterans Affairs, they did acknowledge that despite that holding, that you can have a motion to dismiss if the allegation raised as a matter of law could not constitute a EEO violation. So in this case, the employee alleged in their action that as part of a defense that they had to engage, be subject to two coworkers in a nearby cubicle engaging in office flirtation between the two of them. And based upon that, the employee said that they were subject to harassment. This is before the MSPB. The MSPB ruled that they could dismiss that matter entirely from discussion because, as a matter of law, two coworkers who are having a flirting consistently between them cannot, according to the MSPB, rise to the level of a severe or pervasive work environment, and they allowed that matter to be dismissed. So I really think that some lawyers out there may find that interesting, and I thought I would share that. Okay, we're coming down some of the home stretch now. I wanted to talk to you about establishing an effective anti-harassment policy. So there is a 2004 EEOC document that I sent to you, and it tells you what an effective anti-harassment policy should look at. I think I've indicated, or it's in my bio, that I teach at American University. It's a key executive program, and so as a result, I see lots of different anti-harassment policies that I ask my students for, and I look at them in different federal agencies. I can tell you some of those policies are not well written, and they can be improved. So here's what a model anti-harassment policy has. It has to be written and well disseminated. It has to protect against retaliation. It has to define workplace harassment and include all prohibited bases. It has to cover anyone, including supervisors, coworkers, in other words. It has to encourage employees to report harassment before it rises to the level of federal law. Let me clearly make that point right now. If in order to prove harassment, you have to show under Title VII severe or pervasive, the best way to eliminate that burden is to address harassment as unwelcome conduct that is based upon race or national origin or sex or gender, that adversely affects the working conditions of the place, and eliminate in your agency policy the requirement of proving severe or pervasive. So if you do that, this is very, very critical. If you have a policy that says a single incident of an inappropriate conduct. Somebody says, for example, you look so sexy or hot today, and that, the woman is experiencing that, and she is offended. Like, who are you talking to? You have just violated the policy. If you eliminate severe or pervasive, it's unwelcome. It's based upon their gender, and she's upset, and she adversely affects her working conditions. Doesn't have to be more than just adversely affect. She's upset about it. She has to take time out to report it. It could be the basis of maybe just a reprimand or something. So what you do there is important. You need to clearly define roles and responsibilities. The EEOC Model Workplace Program says anti-harassment programs should be emerged in the Ochiko office as a model, because they argue if it's in an EEO office where you also file an EEO complaint, it can get confusing to employees where they're going. They talk about create multiple impartial paths. Remember, you don't have to go up the supervisory chain. You can go outside the supervisory chain to this agency anti-harassment policy designated official who will assure a report. Assure the report of inquiry is created and reviewed promptly by appropriate improper management officials. Assure appropriate disciplinary action occurs. Ensure confidentiality to the extent possible. Clarify that internal harassment policy is over and above the EEO complaint process, meaning it can go to both. You don't have to, it's not a precursor. Next slide, please. Remember, a prohibition against retaliation, which has to be in a harassment policy, is somewhat a little more complex. Title VII has two forms of retaliation. It's a participation clause prohibition and an opposition clause. So participation clause is you file an EEO complaint. Under 1614, you're participating or you're testifying in that capacity. You're participating. If somebody retaliates against you for that, it's because you have an EEO complaint. But another thing is the opposition clause. And if you are asked to testify in any way, shape, or form in an anti-harassment inquiry, according to the Supreme Court case of Crawford versus Metropolitan Government of Nashville, the Supreme Court has held that you are covered as that is opposition, and if somebody retaliates against you based upon your opposition to harassment by participating in some way, shape, or form in a harassment investigation, that is prohibited under the law. With that said, turning now to slide 25, there are a number of practical tips that I want to say. If you're experiencing harassing conduct, you don't have to tolerate it. Here's a copy of the anti-harassment policy. This is what you tell somebody who's experiencing it. You're encouraged to report it. The agency can't stop harassment if it doesn't know about it. The policy prohibits retaliation for reporting harassment. The policy will protect your confidentiality. You may want to, if you're observing the behavior, you should report it, and this is when you're training people and talking to them, that's what you can tell them. If you're experiencing, you're encouraged but not required to tell the harasser to stop. Remember, sometimes people are not comfortable in telling them to stop because they're intimidated, because harassment is fundamentally can be a power violation where you're afraid that your supervisor will retaliate against you. So the bottom line is, if you're experiencing harassment, you should be encouraged to tell the harasser to stop, but you're not required to. You can go to the designated official, or you can file an EEO complaint. If you're experiencing harassing conduct, you're encouraged to report it as quickly as possible and ensure that the agency will take prompt action. What I wanted to talk to you, that employees oftentimes have real problems in understanding how they get into problems with harassment. And let me just say this. When I just want to make this critical point. When you are conducting, if you want to be accountable in preventing harassment in your organization, the most effective way, and the EEOC has acknowledged this, is to have effective training. In my judgment, training should be in small groups, and you should be talking in plain language. The EEOC acknowledges that having this exhaustive discussion of the law, which I did advise you on because I wanted to make sure we're all understanding what the law is under Title VII, but most employees don't need to understand the technicalities of what is a violation. What they need to know is that you don't have to tolerate harassment, that harassment is something that we take seriously, and here is the policy, here's how to report it, and so you can get out there and talk to the employees. As far as employees, remember, 45%, according to the MSPB, that engage in harassment were coworkers. If you, employee relations specialists, are doing nothing more than talking to your supervisors, you're missing half the reported allegations. So here's what happens with coworkers, right? They follow sometimes the golden rule. It doesn't work. What's the golden rule? The golden rule is do unto others as you would have them do unto you. Well, if you're used to using profanity in your workplace, at home, and you're comfortable with talking to your buddies, making sexual jokes, and then you go into the workplace and you do it and you treat others that you would want to be treated, that it doesn't bother you, you're going to get in trouble. There is no place for inappropriate conduct, golden rule or not. Then comes the platinum rule. Explain this to your employees when you speak to them. The platinum rule is treat others the way that you would want to be treated. Well, that sounds like a perfect example, except that gets you in trouble too. Because if you treat people the way you would want to be treated, again, maybe you don't care. Maybe using sexual comments is a way that you like to joke around. So you're not the standard. And also, you may think that you're treating somebody the way you would like to be treated, or even the way they would like to be treated. But it does not matter, because you could be a bystander that's hearing it and is offended by your conduct, and then you get in trouble. The key thing to say to people is when it comes to harassing conduct in the workplace, you have a great sexual joke that you think people will laugh, there's no place for it. None. I don't care how funny it is. You know, you have to learn, when I say you, whoever you're talking to or communicating to, there is no place for harassing conduct in the workplace at all under any circumstances. If it happens, the agency will address it and handle the allegations appropriately. So again, at the very end of the slides, if you go to the next slide, please, I'm mentioning actually the very last slide. I think, Jason, how much time do we have left? 2 minutes. Do we have any questions? We have one question, so I have a little bit of time. With regard to civility in the workplace, what the EEOC found, and then I'll take this, is that essentially maybe the most effective way to conduct training is not necessarily just to focus on the EEO issues, but to focus on fundamental issues of civility in the workplace. So with that, I've provided, meaning even if it's not an EEO issue, if you treat each other with respect and comfort, you'll be doing fine, and you can avoid engaging in harassing conduct altogether. Do we have any other questions, sir?
We have one quick question you can address, and then we'll wrap up. If an employee notifies HR that her supervisor has been harassing her, for example, unwelcome hugs, would it be necessary or recommended to send the supervisor a cease and desist letter, or would an email suffice? And this is assuming that this would be investigated and everything like that as well.
I think that a email or a cease and desist letter would either way would ultimately suffice. The key component is the employee on notice not to engage in any inappropriate touching and to stay away from that employee altogether while the matter is being inquired to. That would be the key thing. Thank you, by the way, for the opportunity to speak to you on this important matter.
Well, Mark, on behalf of Accountability and Workforce Relations, thank you so much for sharing your expertise during today's live stream training, Addressing Sexual Misconduct and Harassment, Maximizing Accountability. Your presentation provided an outstanding and informational commentary on sexual misconduct and harassment in the workplace. I want to thank OPM's communication staff for your webcast of the live stream training And thank you to my colleagues in Accountability and Workforce Relations for your work on this live stream. Thank you for participating today. We look forward to having you at the next Employee and Labor Relations training. Finally, please remember that shortly you will receive an email with a hyperlink to an online evaluation form courtesy of surveymonkey.com. Your feedback helps us plan future live stream trainings, and we appreciate you taking the time to complete this survey. Have a great afternoon.